As indicated, for better or for worse, I have had the opportunity of representing counties, villages, townships, municipal entities set up by governmental entities such as downtown development authorities, road commissions, multiple health departments throughout the state, as well as the state of Michigan. And one of the things I've learned, my friends, is that I find, it's my bias, local government some of the most efficient and responsive ways of dealing with citizens' concerns. And to further that goal, it's my belief that there should be an efficient operation of local government consistent with the law, and that includes local codes, state statutes, court decisions, and of course the constitutions of this state and the federal constitutions. So I want to thank you for your time that you give, whether you're on the Board of Appeals, whether you're a separate public official, the time that you give. It's because of that and people like you that reinforces my belief in the importance of local government. And I also want to thank Dan Thorell, Mike Jones. Mike was great in helping to come up with realistic but trainable scenarios that we're going to use. The format that we're going to be using is something that I have done for zoning entities, especially zoning boards of appeals, often called ZBAs, really throughout northern Michigan for the Michigan State Cooperative Extension Service and other entities. And the health department here, which based on my experience has typically taken the lead in multiple public health issues, from balancing people's right to smoke with smoke-free environments. We took the lead on that many years ago, to many, many other issues. And that includes having a good, understandable, I hope, public health code. And just so that I understand better the makeup, how many of you are elected county commissioners? Okay. And how many of you have served, even though you may not be a county commissioner, served as an elected official in a township or city? Just out of curiosity. Okay, very good. Any folks familiar with zoning, ever served on a planning commission or zoning board of appeals? Good, thank you. Because there's a very close analogy between decisions and the way decisions are made for a zoning board of appeals and the Board of Appeals under a district sanitary code. And so we're taking the training format, the principles that apply there to what we're doing today. Now, understand my main goals are, I want you to have experience with the standards in our district sanitary code that are typically going to apply to an appeal or to a variance request. The application of facts to those standards, and then the conclusions or findings of fact that you make based upon what the facts are that you've been presented, and we'll talk about conflicting facts as well, and applying them to the standards. And of course, under the law, that decision must be written, and what we've helped to do, based upon, I promise you, very successful usage in zoning situations, the forms, what we'll call the decision forms you're going to see, we have adopted and are going to adopt for use here for the health department, and that format is going to help guide, I hope, boards of appeals to ensure compliance with the law. And as a result, and what's happened, especially in zoning contexts, is that well-drafted and decided decisions, no matter what they are, I promise you, I have saved local units of government in a zoning context, for example, lots of money by basically deterring an attorney who opposes the decision from filing, showing that it's basically unattackable and that any attack on it would be without good faith and subject them to potential sanctions, so that taxpayers' money is not wasted on the frivolous defense of a decision. Okay, and it also includes case law. All of these together can be called the legal aspects of decision making. And we're going to start that right now. Before that, I have to be honest with you. I'm a Wolverine by heart. I went to Michigan undergrad, Michigan Law School, and I recently heard a news release from the U of M Medical School. And yes, I always get this. My wife is a Spartan, and I get thumbs down too. And there was a release in the medical school that they're no longer using rats for medical experiments. Instead, they're using lawyers. And they gave two reasons. Number one, rats can be cute and cuddly and affectionate. And number two, there's some things a rat just won't do. All right. Your booklet is going to have an outline of every slide. And feel free to take notes on that or separately. Beneath that is a summary of what I've labeled the decision-making, the legal aspects that I'll be focusing on. And then we're going to take those legal aspects and apply them to various scenarios that Mike Jones, whom I deeply respect, helped prepare, and we'll be dealing with an appeal that properly should be approved, an appeal that properly should be denied, a variance request that properly should be denied, and a variance request that really properly should be approved. Also, aside from those scenarios, to make it easier for you, there are sections of the sanitary code that will be applied or used in making decisions regarding the different scenarios that would come in front of a Board of Appeals. So when you see the format that we're using for the proposed decision, you can refer specifically to just the pure wording of the Public Health Code. In other words, the Sanitary Code, Board of Appeals training, and then also to make it easier, separate are the specific standards that have to be applied to an appeal and the standards that have to be applied to a variance. Okay? Please understand, my friends, that variances and appeals, and the Board of Appeals under the Public Health Code can handle either one or both, need to be decided not just on what you think is good. Oh, that's a great idea. Or because a very nice taxpayer wants it. It's a question of applying the standards in the ordinance to the facts so that it's not attackable. What you don't want is to have a neighbor or some environmental group who thinks that what you're doing is having an adverse impact on the environment, or even the property owner who doesn't like your decision, to be able to attack it based on procedural irregularities. That we can avoid, and that allows for efficient, equal decisions and avoids wasting taxpayers' money. So, the District Sanitary Code obviously provides for a Board of Appeals for each county and 5 members, and commissioners can also serve on the board. And if you look at the sections of the code that relate to that, with 5 members, the code provides that decisions can be made by 3 people, but if only 3 are in attendance, if you look at the code and the sections of the code, all 3 have to agree on the decision, right? It's not just a majority of the 3. Okay, otherwise, that's a procedural irregularity that can be attacked. Okay? Questions on that? Now, as I mentioned earlier, appellate decisions that aren't consistent with the law, and by law I mean the code, as well as case law that I'll be covering, obviously can result to unjust decisions to the property owner or to the community at large or neighbors, provide for unequal treatment, which we don't want, and of course, as I've mentioned, and what I've seen far too often, is wasted taxpayers' money on needless litigation that can be avoided because of procedural irregularities. A Board of Appeals member, as you note here, is essentially a judge. They're no longer, if you're a county commissioner or you're elected official. Elected officials aren't used to having their judgment, their discretion challenged. But once you're sitting in any type of appellate board, okay, you're kind of like a judge. And as you'll notice in the final, using the legalese in the last sentence, it's quasi-administrative. Not a pure administrative decision, because that's made by the health department, and it's not purely judicial, so the courts call it quasi-administrative. One of the things that the health department should be doing, and this helps reinforce that, is that applications must be complete. And Section 11-4 of the code lists those requirements. It does no good to process an appeal that is incomplete, because if you as a Board of Appeals are not given the necessary information, you can't properly make the decision. It can be attackable. And technically, as that last line says, and as we use the word specifically in the code under Section 11-4, an application that is incomplete is not ripe, and that's a legalese term, for a decision. That simply means, under the law, an incomplete application should not be processed, okay? And I don't want to see an incomplete application coming before a Board of Appeals. That's got to be analyzed by the health department. Follow me? That just simply is a question of trying to be efficient and fair to the taxpayer and the public at large. All right, the other thing, I've seen this in zoning cases, and I'm sure it's occurred here, site visits. Under the law, you can visit the site if you need to, prior to the hearing, or even during the hearing, which we'll talk about. But you're subject to requirements of the Open Meetings Act and or other ethical considerations. Whether you're going to the site before the appeal because you want to get an idea of the layout of the land or whatever reason, or you're going because you adjourn your meeting and the group goes out there. What I've seen, and I've especially seen this with zoning boards of appeals, members going out, having discussions with the property owner or other people regarding the merits of the appeal. They're telling you their position. That's stuff that's got to be presented during an open meeting. Do you follow me? And having a discussion with the property owner, no matter how well-intended you are and how nice you want to be, is simply violating the law and allows for a procedural attack. So it's one thing to say, is this your property? Obviously, they can say yes. But then discussing the merits of appeals should not happen. Similarly, hearings can be adjourned. You can go out to the site. And again, it's an open meeting. And other people can go. Minutes are going to be taken. And until in an open meeting, you're in a position where you can ask questions of the applicant, which you can do, obviously. You can't talk to the applicant or anybody else, their expert, if they have an engineer there, for example, until you come to that part of the meeting. Okay? Because again, failure to do so allows for a procedural attack. And as I've said repeatedly, the requirements of the Open Meetings Act must apply. I've seen situations, you look at the first highlight there, where members of an appellate body, zoning board of appeals or board of appeals like this, communicate with each other regarding email or phone call. What do you think of this? Here are my thoughts. What do you think? My friends, that's deliberating outside the scope of an open meeting. Follow what I'm saying? Okay. Yes, there should be discussion. But whether you're discussing the facts or your ideas regarding how the code applies, you do it, please, in an open meeting where you've got people taking notes, where the public has a right, regardless of what side they might be on, to hear what's being said. Because obviously, if you have a discussion outside of that, even by email, you're violating that, okay? And I've seen attacks because that has happened. It's been in a zoning context, but I don't want to see it happen for us dealing with our district code. One of the things that's unique about your code is that, as you will see, the Board of Appeals has broad authority. A citizen can elect to have a variance request processed by, and when I use the term health officer, I mean any employee of the health department, including, this means in our situation, we're talking about sanitarians. So if I use that general term, because the code uses that, it means anybody under the generalized supervision of the health officer. So, health officer is limited to existing situations. Board of Appeals can grant variances for existing situations or new situations, where, for example, where a house is going to be built. But you've got to make that decision based on the standards in the ordinance, not what you think is good, not because they're good people and taxpayers that have been properly complying with their duties as citizens for the years, but do the facts meet the standards required in the ordinance? If not, your decision, no matter how well intended, can be attacked. Now, what I can see happening in our situation, and again, I would hope that our health department staff would stop this next one down here from happening. I can see a person, property owner, filing an appeal, okay? And based upon analyzing the facts, the Board of Appeals says, I'm sorry, your appeal can't be granted, but under the facts, wait a minute, a variance might be appropriate. But their application has not said that they're requesting a variance. Do you follow me? They're just saying they're requesting an appeal. That creates what the courts would call a due process problem. The public, under the public notices of the meeting, has a right to know what's being discussed. And because it's not listed as one of the things in the application, it's not in the application, you can't do it. And so what I don't want to see is a situation like that in which you have an appeal where a variance is appropriate and you deny the appeal and now the person's got to go through the process again, do you follow me, of filing for a variance. I want staff to see that situation in advance, advise the property owner. So if they have to, they're applying for an appeal, right? And or a variance. Or they may just simply say, give me a variance. But the key is doing it properly and with a completed application. Okay? And I've had this happen also, where I get a call from a staff person, quite often a zoning administrator, raising the issue, Jim, this is appropriate, what should we be doing? And then I may provide. Don't waste their time just in this one hearing. Please tell the applicant that they should go back and be amending their application. If the applicant won't do it, you can't make them, of course. Then you have no choice. You've got to respect their wishes and proceed, even though it's a bad decision. Okay? All right. The burden of proof, another legalese term. And while it says for appeals, it really applies to the standards in a variance. The applicant has the obligation to provide you with evidence, facts, that the standards are met. Each standard for the decision. If you want to see what those standards are, it's going to be in your handouts. Look for section 11-6. Okay? Those are the standards that you've got to deal with for an appeal. There are different standards for variance. And again, the form that I'm recommending that the health department use for appeals or variances is going to list those standards. So ideally, you can't miss them. But if you're prepping in advance, reading stuff in advance of the meeting, please go to the sections of the ordinance. Now, when there's conflicting evidence, you've got to decide which is the most credible. The law is supposed to say, they give you the choice, assuming that it's a reasonable decision, to decide which evidence you decide to follow. What I have seen is expert opinion versus lay opinion. Okay? Real life example, Charlevoix, in a zoning decision. Back when bed and breakfasts were starting to become a big thing, neighbors were objecting because, wait a minute, if you do this, parking, it's hard to find a parking place on our street anyway, and you have bed and breakfast where multiple people there, typically on weekends and especially during the tourist season in the summer, there's going to be no place to park, right? That's a lay opinion. It may be right, but ideally they would go to the municipal planner who would analyze parking in the area and give an informed decision, or they bring in some expertise. In the context of what a Board of Appeals with our code would deal with, largely it's going to be engineers, okay? And so just please be careful of evaluating a lay opinion, which may or may not have any credibility. Typically, in fairness, people may be well-meaning, but it does not, versus expert opinion. Obviously, as I've said, decisions must be made in an open meeting and in writing. And as you're going to see from our examples, the decision's got to be supported by facts in the record, why the standards have been met or not met, and you state whether the appeal was granted or denied, or in the case of a variance, whether it was granted or denied. This is important too. I have seen when written decisions are made, two good. There are three scenarios, but two that work well. One, as somebody's trying to complete filling out the form, you've completed the hearing, you've had the applicant present their evidence to the extent it's open to the public. They have a right to speak, right? And you're considering anything that the public has issued. Could be neighbors, could be an environmental group. You've closed the hearing, you now begin deliberations. You're discussing things, you generally reach consensus on the issues. Then, I've seen situations where they adjourn for 20 minutes and a person, could be the chair, could be a member of the board, tries to complete with some suggested wording the rest of the form that you're going to see. Okay? Then they go back into open session, discuss and change the wording as needed, and then are able to vote on it. In complex situations, I've seen hearings adjourned to a new date, and you get some expert help in drafting the opinion. I've had situations in which a zoning board of appeals, knowing that they're competing, no matter what decision they made, somebody was going to object to it, adjourn and say, legal counsel, you've heard our discussion, we've completed all of our discussion, come up with a suggested draft. And then a continuation, a new hearing date is set. They then alter whatever they want, and then they have a decision. Follow me? Any of those options can work. All right? And you see that in the listing of items there. In complex cases?
There you go.
Okay. Obviously, that's a summary of what I just said. Okay? And again, you don't want to do that all the time because you're adjourning to a new date, but I promise you in complex cases, it's fair to the property owner, it's fair to you folks that the decision be made properly and ideally unattackable, at least unattackable for procedural things. Obviously, they can disagree with your factual determinations. That people have a right to do. But again, we don't want a procedural problem. Okay? Again, that first point, I've said it a couple times. And this, again, is a summary based upon my experience that I promise you those items there are accurate. The key, my friends, once again, is apply the standards in the ordinance, not what you as an individual might think is a good idea. Last, I only mentioned this in passing. Under Michigan's governmental immunity statute, all people that serve in public positions are immune from liability unless gross negligence occurs, which is a willful decision or refusal to follow the law. What I don't ever want is for people who volunteer their time to be subject to threats of litigation, and I'm sorry to say, I've seen that, I hate to say it, with a new influx of attorneys that represent property owners and zoning and other stuff in northern Michigan suing board members, and I've gotten sued for my advice to different appeals. They're trying to do that to put pressure on the governmental unit, okay? And by following the approach we're talking about today, my friends, you're going to avoid that. By deviating from it, you're allowing some plaintiff's attorney to try and allege gross negligence, that the governmental immunity statute doesn't apply, and now it's a question of whether the county insurance is going to take over, and then ultimately there'll be and even if it does, there'll be an increase in premiums. Okay, actual hearings. Obviously, you with experience know that there needs to be a written format for meetings. The chair controls it. And it's my suggestion that good Board of Appeals members read all the submitted materials before the hearing. And the ones that are really prepared that I've seen actually may have a list of questions that they may be asking the applicant, or if there's an expert witness for the applicant, or for, in our situation, for a sanitarian, or for legal counsel, that they have their questions there. They're not discussing with anybody beforehand, but they're prepped with their list of questions. Again, I repeat, you respect personal opinions, but they've got to be supported by scientific or evidence-based information, not just I think. When you're not sure, as I've said, be preemptive and have legal counsel attend the hearing to try and make sure, not to tell you what to say, but to make sure whatever decision you make procedurally complies so it can't be attacked procedurally. Again, avoid applying personal perspectives, stick to the code, Open Meetings Act, obviously that's obvious, following Robert's Rules of Order, for example, conflicts of interest. To the extent that it's appropriate, I've gotten calls in the past from Charlevoix City Council members, from ZBA members elsewhere, saying, Mr. Young, we have this hearing coming up. Here are the facts. Here's my relationship. Do I have a conflict of interest? I don't want to waste my time preparing if I shouldn't be there. I don't want to contaminate the decision either. And so if an alternate should take my place, please let me know now. Okay? And properly done, the attorney, whoever that is, should provide a written opinion. So if the board member has to recuse himself or herself, you've got a basis for it. Okay? We'll also be talking about, with a conflict of interest, what's called an appearance of impropriety. That's been litigated, actually, up north. An opinion coming out of Grand Traverse County summarized it quite well and referred to all the court decisions. An appearance of impropriety could be where you may have or do have a financial interest in the outcome, or a family member, or a business that you work for, which used to cause a big problem in Midland, right? With Dow, for example. And there are certain now rules that say if there's so many conflicts like that because you're dealing with your employer under the law, as long as you state those conflicts, you can proceed. That's only if you then wouldn't have a quorum to proceed. Now, an appearance of impropriety can be real-life examples. A ZBA, Zoning Board of Appeals, has made a decision. A supervisor comes in who helps appoint these people, or a township trustee, and because they're a neighbor, they're impacted by this decision, tries to either support or, in the case that went to the court, have the ZBA deny the variance. The question was, wait a minute, you appoint these people, follow me? Is the pressure you're putting on them an appearance of impropriety? And the court said yes. Okay? What about, in the case of Health Department appeals, a member of the Board of Appeals is a builder, does excavating, does other things, and then may be used by the applicant if they get their variance or win their appeals. That, my friends, is an issue. Now, if you have no idea that that would happen, obviously you can't, know what's going to happen. You have no advanced knowledge. But if that person has made contact with you and gotten bids from you, for example, my friends, you've got an ethical and legal obligation to put that on the record, or get advanced legal advice as to whether you have a conflict of interest. So conflicts of interest can be subtle in terms of calling what they call an appearance of impropriety and ignoring it. Remember, let's go back to Michigan's governmental immunity statute, where there's a willful disregard of the law. You don't want that. When in doubt, have the conflict of interest question or the appearance of impropriety question resolved. All right. In terms of the legal aspect, my friends, that's it. Now we're going to go to the scenarios. For that, you want to take a short break? Anybody, or keep going? All right, let's keep going. Real quick, though. There was a boat full of tourists outside a Caribbean island with a glass bottom, looking at coral reefs and fish. The motor died. They see a storm coming, and the wind is starting to push them away from the island. People can't, because of poor connections, call with a cell phone. They decide as a group, somebody's got to get to shore, have a boat come out and save us. One of the members in this small boat says, well, I swam in college. I can make it to shore. Jumps in the water, swims over the coral reef, makes it about halfway to shore, and all of a sudden, fins start appearing in the water. He's attacked by multiple sharks, ripped to pieces. The wind's taking him further out. There happens to be a lawyer on board. Says, I'm not really a good swimmer, but for exercise, I do try and swim a bit. We have no choice. I'll go in and try. So the lawyer jumps in the water, makes it about halfway. The fins come up again, start converging on the lawyer. And all of a sudden, they get next to him. They form two lines, escort him to shore. And somebody in the boat says, good grief, what have I just seen? Mike Jones, what did they just observe? Professional courtesy. All right. Mr. Jones, scenario number one. Let's give a couple of minutes. Please read, my friends, the document that says memorandum. It should say example A in the corner. Yes, some of the corner letters may not always be A, B, and C, but this one is A. Yep. Now, also attached to it is reference to a technical guidance memorandum written by a previous chief environmental sanitarian. I'll just have Mike summarize that, okay? So what we'll do now, Mike will summarize the key facts in the memo, okay? And this is a type of memo that our sanitarians should be submitting to the Board of Appeals when there is an appeal, okay? So Mike will cover the key points there for you as you finish reading, and then, so you don't have to read it, he'll summarize the key points in the technical guidance memo. Mike?
Key points in this scenario to focus on would be the notation in the soil profile that modeling was beginning at 9 inches, and based on that and some other observations, the maximum high groundwater table elevation was determined to be at 9 inches, which is less than 12 inches stated in the code. That the engineering firm that did groundwater monitoring in number 4 in the memorandum, that they did groundwater monitoring between the dates of March 2nd and May 22nd, so approximately 2.5 months, a period of time. And that the engineer also provided information indicating that the recorded precipitation totals for the period of time in which monitoring was done was within 90% of normal averages. The last two items in regards to the monitoring period and the providing information on the precipitation totals are part of that groundwater monitoring technical guidance memorandum that Jim was talking about that's located near the back of your pamphlet information. And that refers to some of the procedures, a couple of procedures. Number one is the monitoring done by a professional engineer. Two, that it continued over a period of not less than 8 weeks, 8 consecutive weeks, and that precipitation information was provided.
Okay, now under that, also in the corner that does say example A, is something that should say decision in order. Okay? And this happens to have a Charlevoix County heading, applicant John and Paula Joe Peters. Everybody have that? You can see this is the format that I have provided the health department that I suggest be used. Got the property description, the names of the applicant. You have what the application is for. In this case, it's an appeal. Then the really important part. Well, the form will just have the standards down. This has an example of the findings. So look under findings of fact regarding the appeal. The board finds that the applicants have established the most accurate determination of site conditions relating to their application for an on-site sewage treatment and disposal system, meaning the application for the following reasons. Now, so you also can follow this. The other handout that says Sanitary Code, Board of Appeals Training, and the first item is a variance. This saves you having to look it up in the code. All it is pure code writing. I want you to turn to page 2 that should have in the top corner, 11-4 appeals. Sanitary Code, Board of Appeals Training, page 2. Okay? Those are the standards. And in this decision form that I've recommended to the health department, you'll see. The question number 1 is, has there been an accurate determination by the health officer of the existing site conditions? Remember, in this case, complex. Sanitarian went out, did one set of measurements. The applicant went out and had an engineer who did a second, and to be blunt, more comprehensive set of testing over a longer period of time pursuant to an internal memo that helps interpret the code made by a prior sanitarian. Everybody follow that? So there was testing by an expert witness for the applicant that went above and beyond what was done by the health department. So in this case, it says the applicants have established the most accurate determination of site conditions, and then it explains the reasons why. And essentially, it summarizes their engineer's report regarding the extensive additional groundwater monitoring that was done, and then it also refers as an exhibit. Not only is that report an exhibit, but also as an exhibit is the technical guidance memo that was done internally by the health department a number of years ago. Okay? Then you'll see, again, with the standards, the health officer, that they must properly interpret and apply the requirements of the code to existing conditions. Obviously, I'm paraphrasing. In this case, they find the health officer failed to properly apply the applicable requirements of the code for the following reasons. Okay, and yes, he applied the sections, but that because of the more recent and more comprehensive data, it shows that those code requirements are met. Can you understand that? So it's going through each standard and explaining, in this case, why the applicant's position is correct. Okay? With our form of the general standards under C, the applicant is shown by competent material and substantial evidence that the appeal should be granted. That's legalese for saying they have to show, more likely than not, based upon reasonable evidence, not just lay opinion, but actual measurable facts or expert opinion by a competent expert, that the standard is met. In this case, shows the applicant is shown by competent material and substantial evidence that this appeal should be granted for the following reasons. And then, of course, summarizes, as you'll see under A and B, about the additional groundwater monitoring that was done by the engineer and how it establishes that the code requirements are met. Everybody understand that? And, of course, then the decision. The appeal should be granted. All right. Any questions on that? Now, in an ideal world, an applicant would submit that to the health department in advance, that additional data, and that they would make that determination. It wouldn't require an appeal. Okay, but for training purposes, it's additional information that shows how an appeal in this case should be granted. Now, look at the next one. And mine says, example D, okay? On this, again, just for training purposes, this is an appeal by the same people, but simply for purposes of the seminar, they didn't get the additional groundwater monitoring by a professional. Follow me? So all we had were the measurements taken by our sanitarian. Okay? Based on that evidence alone, I'll let you go through the standards. You'll see findings of fact regarding the appeal. In this case, the health officer accurately determined the existing site conditions for the following reasons. And it summarizes the evidence contained in in this case, the sanitarian's memo that regarding the measurements that were taken. and then they properly applied the requirements of the code. Obviously, there's sections relating to groundwater maximum elevation, and it's a question of applying then the facts to those standards. That was the standard that applied. Number three, of course, the applicant then has to show by competent material and substantial evidence the appeal should be granted. In this case, if the applicant has not shown competent material and substantial evidence, therefore, it should be denied. Follow me? Because there's really no evidence that would justify it. Okay? So, which is why I would hope in a real-life situation that people would communicate with the health department, who then could advise them, you have the right for some additional testing. Here's an internal memo that authorizes it, and I would hope that people would go to that extra expense to do that. Okay? Question? Yes, sir.
Actually, maybe two. To back up just a little bit, what happens if, when we're at a hearing, and the board discovers that the application is not been, as you say, right? At that point, is the meeting adjourned?
Yes.
Is it not, or what?
The application under the law should not have been processed to begin with, okay? And in this case, in fairness to the applicant, you would simply adjourn it, if you will, or in this case, say, we're stopping the hearing. We're not necessarily denying based on what we have no choice but to deny it. But we are adjourning without date. It's up to you to submit a new application so that it is ripe. Do you follow me? And a hearing would be rescheduled. Could you get away with denying it? Yes, you could. But sometimes for PR purposes, because the applicant may have made an honest mistake, okay? And to be blunt, again, I would expect, I don't care if it's a city or county or township that has zoning, I would expect the zoning administrator and the planner to look at that. I would expect our staff, right, at the health department to help make sure that the application is complete.
Our staff wouldn't make that mistake. So
I understand, my friend, but that's...
But now, second question. What if we go through and we receive what you just said and the findings of fact from the staff that is to be approved, and if the board feels that he's not correct, can that be denied based on the opinions of the board at that time?
On your opinion, no. Question, if you think that the sanitarian was wrong, if that's what you're saying, what are the facts? What facts are you relying upon to reach that conclusion? If there are facts, no problem, right? But if it's just the fact, that they're good, decent people, and I've seen this, thousands of times, making an application that you would prefer to give, that common sense tells me I really want to do that because I'm a good person, they're good people. My friends, you've got to apply the standards in the code. Okay? And again, there may be a way, while that appeal may be denied, if they go back and get some expert help themselves and meet with a sanitarian, there may be a way, for example, of finding a way where they can accomplish what they want, even though their initial approach didn't work. And where I've seen that typically, again, where people are trying to save money and they want to push things along, they don't want to take time of going to see an engineer, for example, right? And do that. And they push an appeal or a variance request really faster and sooner than they should. Okay? So to answer your question, if it's just your opinion that they're wrong, you had better be able to cite some facts where the sanitarian was wrong. If not, you deny it. But then what I would do if I were in your shoes, I would recommend that they sit and meet, again, with the staff, and it may have to be higher up the chain. Is there a way, maybe with some additional outside advice like we had with the first example, which is why I did that, with an engineer, so they find a way of getting what they want, but consistent with the code. Okay? That, my friend, is exactly what I would do sitting in your shoes.
So then you don't deny it, you adjourn the meeting again until that can be resolved?
I would not, no. Because based on what they've given you, it's got to be denied. That doesn't mean they can't reapply with a different set of facts. Do you follow me? That's why then I would recommend that they get some expert help, meet with staff, right? And then a new application be made, and if they don't get what they want, it's a different set of facts, so it's not the same appeal. Follow me? Okay, that's the way to do it. Sir?
Jim, we've had some appeals hearings where there are more than one expert that are presenting conflicting sets of
Yes, sir.
facts. Is it in the discretion of the appeals board who we assign more credibility to?
My friend, it's one of the points I was going to make later on. Great question, Scott. The answer is under the law. As long as you've been given expert opinion and there's a rational basis for it, you can pick whatever you want. And under the law, even if it's appealed to court, the courts aren't supposed to overturn you because they thought the other expert was more credible. Do you follow me? As long as the expert that you believe has the background, right? They truly are an expert in the field, and what they're providing is evidence and not just speculation. Then, under the law, even if it goes to court, the court is supposed to follow what you decided, even if the judge disagrees. Okay? So yeah, it's your call under the law. All I ask is that there be a rational basis for doing it. The expert be competent, and they're providing you some type of objective data. Okay? Yes?
Jim, you mentioned the green book up there, which I've got at the back of the office. Is that the code or the law?
That is the sanitary code. Okay? That is the law. It's a code. It's the same as an ordinance. It's called a code because that's what Michigan's Public Health Code allows. It could be called regulations. It could be called an ordinance, which is what we would do for a city, right? The township or county ordinances. So it is the law. It is the law. It's a local law, and it's subject to, because it's enacted pursuant to the Public Health Code, it's subject to the Public Health Code, subject to other state laws, the Constitution, right? Federal Constitution. No, sir, it's the law. It is the law. Okay? So, and that's why this type, understanding the standards and applying them, is so important. It's the law. And that's why what I've seen so often in boards of appeals, especially up north where we tend to know each other and be more sensitive to property rights and things like that, I see so many people saying, I really want to help these people. They deserve this. They got to have some facts, my friends, to meet the standards. If not, your decision is attackable, and it's not fair to them, not fair to neighbors. Okay? It's the law. Okay. Next in the handouts, this, again, it can be quick. This also should be the Peters. All this is because I've seen this in a zoning context, and I'm afraid you may see this sometime. The people may decide, well, I'm not going to appeal their decision. Somebody told me under the code, you've got a right to grant a variance. So give me what I want. You can vary the conditions of the code. Follow me? So they didn't get any additional testing, okay? Like our first example where they really should have been issued the permit, and they just request a variance. And you will see then how, and you look at the standards, they're different than for appeals. Okay? Look at the standards. The board finds the health officer. Wait a minute. This should be the variance one. Strict compliance cannot be achieved. You see that one? See the standards? And also in the other handout that I've been referring to, it's now the first page. That's the actual code. And you'll see in this form that I've developed for the health department, standard number 1, strict compliance cannot be achieved. Number 2, are there exceptional or extraordinary circumstances or conditions? Number 3, the variance is not due to a self-created condition, and typically that can be created by the property owner or a prior property owner. In Standard 4, the variance will constitute an improvement to existing conditions and basically not be have an adverse impact to neighbors or the environment in general. I mean, I'm paraphrasing the standards, but you can look under there and see under my example where the people, instead of appealing, they didn't get the additional testing. They just simply said, give me a variance. I'm a nice person. Okay? I've owned this property for a long time. I want to retire. I want to have a vacation home for my family. I've been paying taxes for decades and decades. Just give me what I want. But they don't give you any facts. Follow me? There's no way, my friends, you can meet the standards without facts. And again, I would, to the extent that they've ever talked with our sanitarian, I would hope a sanitarian would explain that to them, because that's a waste of their time and your time. But people have a right to do this, okay? And I'm sorry to say I've seen it in a zoning context. I'm afraid you folks might see it in this context. Follow? Scott?
Jim, I'm sorry to take you back, but I should have asked this question earlier. On your example A, which is dated May 25, 2021, in paragraph 5, where they state that they've been paying taxes on the property as a buildable site since 1976. How is it they can be taxed as a buildable site and then be determined to not have? And if that's the case, what's their recourse as far as the overcharging of taxes? Do they go to my clerk? Really? Or
Well done. All right, now this is where I can smile. Mike created scenarios, and some of this is based on what he's actually seen, okay? So let me explain why he put that there, and I will answer your question directly, based on my background. Go ahead.
I can shed some light on how this occurs, because it actually has occurred in appeals. Those types of things come up. We have townships who have sent out notices to their residents stating that unless you show your property is not buildable, that it is assumed to be buildable. So that doesn't happen all the time, but we've had these bursts of that over time. So we get a bunch of evaluation requests to review property, and we let them know the findings, whether it is buildable or not buildable. Then the taxes are adjusted accordingly. If a person has not requested that of us to look at it and make a determination, then typically the township assumes it's buildable, and they tax you based on it being a buildable property until determined the otherwise. So if this property had never been evaluated by the health department to say, no, it doesn't meet the code requirements, you're not going to be able to build on it, they could have paid taxes all those years with the assumption from the township that it's a buildable site. That's outside the health department's responsibility. We've had people come to us and ask that we deem their property unbuildable because they don't want to pay high taxes, and then they actually come back after that and want to get a permit. So that has to do with the township, and it has to do whether we have done a previous evaluation or not. In this case, we hadn't. We've not looked at this property before, so there was never a determination of suitability up until the point of application for the permit. That answers the question.
well, and I appreciate what you said, Mike, but in this scenario, they were being taxed as a buildable site.
Right. It's a presumption of suitability.
Yeah, okay. It is a presumption. In reality, as you know, they can appeal, okay? And you only go back so many years to try and get a rebate on taxes. But they would be limited in that. But I specifically left that in there because obviously, sitting as a citizen, I wouldn't want to see one of my constituents paying on a buildable site that in reality is not buildable, okay? But again, the property owners have responsibility too to look at their land.
Follow-up question then, Jim.
Yep.
Because the sanitary code may have changed from 1976. So what was once deemed a buildable site is now not deemed a buildable site under the current code. Does that change the scenario?
Oh, there's Mike, go ahead. Go
In
ahead.
our district, our codes have changed a few times. Every change to the code has been more lenient rather than restrictive. So anything that passed in 76 was still passed today. So where we didn't have mounting systems and ATS before, we had just in-ground systems and those requirements for in-ground systems. Through the process of changing the codes, we've allowed mounds and then allowed ATS. So the code has become much less restrictive over time, not more restrictive. So in our district, I don't know if I can answer for other districts.
Yeah, but even then, Scott, under the law, if the people have done nothing with their land, they're subject to whatever codes apply at the time. But however, if they started, and I've seen this in reality, start construction for whatever reason, it could be illness, could be who knows what, stop construction. But they've already altered the land a little bit, and the township hasn't gone after them. They may be a basis for variance. Okay, but it depends so much on the background facts.
Does the new code allow holding tanks?
No.
So that's a case where it went from being buildable to not buildable,
Holding tanks are not in any of the codes, never have been.
but they were
It's holding tanks have been approved as a last resort alternative for existing uses only. When their system fails, the site is in such a condition with water table, distance to water, surface waters, that type of thing, that in the opinion of the health officer, that any on-site disposal would be detrimental to the environment and public health. So that's when we issue holding tanks. Outside of that, we don't issue holding tanks for anything other than extreme circumstances and replacement and existing uses only. No change of use, no successibility. Does that answer your question?
Forgive me, I'm showing my age here. There's a type of a septic system that the code allows. It's a more modern approach that was included in the last change.
ATS?
Yes.
Advanced treatment system.
Advanced treatment systems. I mean, that's a real benefit that didn't exist before, okay? And so, to sort of answer your question, we now have some alternatives that didn't exist before.
Correct.
Yeah, ATS, Advanced Treatment
I was
Systems.
just going off back and said they never made the code more restrictive, and I thought they did was
Holding tanks, to my knowledge, holding tanks have never been in any version of our sanitary codes as a provable alternative for new construction, change of use, or successive development.
Okay?
They do exist, yeah. Because we are in situations where there's an existing use that has a failed wastewater system, that the best alternative for that waste is the holding tank. So we issue that because of the potential impacts of installing a disposal system on site, potentially to the environment or to public health. So it's in a holding tank that gets pumped and hauled away to an improved disposal location. Does that make sense?
Okay. All right, now we go to the last scenario, but also a complex one. And it is one I can tell you in advance that in reality, I would hope that a citizen would, because it would be done faster, request a variance under this situation with the health department directly, the health officer or sanitarian, so they don't have to go through a hearing, but they've got a right to go directly to you. Okay? So for training purposes, I had this scenario come directly to the Board of Appeals. It's a bit more complex, but also you can see, I hope, why when you apply the standards, which are fairly strict, a variance should be granted. Okay, before we get to that, we also have a new sanitarian that they had brought up with me from Bel Air. I've got a question for her. Don? You're here? How does a lawyer sleep?
The lines of one side and then on the other.
Yeah. He lies first on one side and then turns and lies on the other. Okay. I usually get good responses to these jokes, except when there's lawyers in the audience. Okay. Look at the last memo here. This is for the Potters. As you summarize and look at the memo and the findings, they want to get a variance to construct a successor 3-bedroom home to replace a previous 3-bedroom home that was lost to fire. The original mound system a variance was obtained in 2006 because it's located 78 feet from the lake, not 100 feet as required. Okay. Any other highlight points you want to make?
Yeah, just a few things to focus on. That this is a successive building of the same number of bedrooms, same square footage, basically the same square footage being proposed to replace a home that was lost to fire. The department issued a replacement sewage disposal permit in 2006, and the variance was granted at that time because it was a replacement system for an existing use. The department issued a variance to section 5-12, the horizontal distance, isolation distance from the surface. And that system was installed in 2006. Other than that, the system meets all other requirements, other than the horizontal isolation distance to surface.
Okay. So next and last, but also important, very important, is the decision and order. And again, you've got the description of the property, what they're seeking, and now we apply the standards. Strict compliance cannot be achieved, and you'll see the facts listed that support that conclusion, and there's reference by an exhibit, which I just called Exhibit X. That's based on like the memo that Mike prepared for us, that's incorporated as part of the record, and it simply can't comply with a 100-foot requirement. Number 2, are there exceptional or extraordinary circumstances that has not been created by the applicant or due to the economic hardship? Let me explain first what that wording can mean. The fact that a person wants to build a home too large for their lot, it's going to have too much affluent, that's their personal decision. Okay? And they could comply with the code, but they don't want to because it's going to be too expensive. I've seen that argument made in zoning boards of appeals. So it's more a question that the circumstances are due to the terrain, if you will, above and below ground, and not just to their personal preferences. Okay? And obviously you can see under the findings, the home was destroyed by fire, the existing drain field was permitted pursuant to a variance, and so there are circumstances tied directly to the property, if you will, and not just a personal preference of the applicant. And again, number 3, variance is not due to self-created condition. Okay, and again, those are examples similar to what I just gave you, where it's done directly by the person. This obviously is not. They want to be able to build a home and still comply with an old variance that had been issued in 2006. They're essentially asking for the same thing, even though it's a replacement home. And number 4, it'll constitute an improvement. Well, obviously, it's going to allow removal, obviously, of all the debris, allow use of the same sewage treatment system that, and I added this, historically has operated properly. The health department has no evidence that it hasn't. So there is going to be no adverse impact to the environment. And of course, then the variance would be granted. Yes?
Even though the variance was approved back in 2006 to have the shortened offset from the surface water, would there need to be any evidence presented saying, no, sewage is not reaching that surface water to show that it's not, that the greater level of protection for health, welfare, and safety of the public, right?
Yeah.
Do you need to positively prove that, or can you just say it was approved previously and that is sufficient?
You could do either. My first choice would be some sort of measurement showing that the existing mound is not having an adverse impact polluting, right? The lake that it's draining into, in this case, Otsego. But you also could say, based upon that there is no historical evidence of a problem, okay, and the fact that this is going to be essentially functioning the same way it has in the past, okay, I don't think a court would overturn that as being an arbitrary decision. But again, my first choice would be some sort of measurement, okay, and ideally measurements done by our department, not going out and having them spend money on a separate expert, okay? So this, sir.
Sorry. I didn't mean to interrupt you right off, but at some point, could you touch on what exceptional and extraordinary circumstances would be, and maybe some examples, and maybe some examples of what would not be exceptional and extraordinary circumstances?
Typically, those would be circumstances relating to the layout of the land. There may be a hill that stops construction of anything and it pushes it closer to the water. And if they want to build a home similar in size to those elsewhere in that zoning district, for example, okay? That's not their fault that there's terrain there necessarily, okay? Assuming that a home with a proper variance could be built consistent with those typically in the district. So special or extraordinary circumstances typically mean it's due to the terrain in its natural condition, not altered by the owner or previous owners who could create their own hardship, so now I get what I want, okay? It's due to the unique natural condition of the property is typically how a court would rule.
So the presence of the condition that led to the denial, lack of isolation from surface water, it itself is not an exceptional or extraordinary circumstance. And also then the constraints of the property boundaries being too small to allow that isolation is not an exceptional extraordinary circumstance, but of not meeting the distance to surface water. You follow me? So you don't have enough property to meet it. That's not an exceptional extraordinary circumstance. It is what it is.
No, but if the area that will meet, for example, the horizontal distance, okay, meets it, but it does require it being a little bit closer to the lake where you've got to be within the 100 feet.
Yeah.
But that, as experts in these environmental issues, the health department is satisfied that there can be sufficiently good sewage treatment that's not going to pollute the lake. That's a classic example of extraordinary circumstance. You follow me? The property owner is not creating that mound. That's just the way it is. That's where the mound is located. Okay? And it can be met. There's no adverse impact to a neighbor's well, right?
Yeah.
To a lake. That's a classic example of an extraordinary circumstance.
So one that always comes to my mind is in an appeal, the exceptional and extraordinary circumstances that were cited as the justification for granting the variance was that the property was surrounded by water on 3 sides. In my mind, that's not exceptional and extraordinary. It might be an odd situation, but not exceptional and extraordinary reason for granting a variance. It's just a condition of the property. It is what it is.
Okay, again, the question becomes, as a matter of what I would call fact, can a system with a mound system or ATS system be installed that's still going to meet these standards? And typically the big one is not having an adverse impact on neighboring property or the water, okay, and otherwise comply?
But it has to be demonstrated by the appellant.
You betcha. Okay?
Not
But I'm telling you, where I disagree is that those could be extraordinary circumstances. You follow me? The key is that the standards are met and the system can be done safely and not have an adverse impact on somebody.
Burden is on appellants to show evidence that that is the case, not, burden is not on the health department to prove that it's not.
Correct. The burden is on the applicant. Okay? There was a question over here. Sir.
Yeah, actually, this turned into a third question, and they're all somewhat related here. Based on what you just said with the terrain and the neighboring homes and distances, there are a number of homes in this county that, due to setbacks from the lake, they can't build a septic system on what you would call the ideal high ground on the property. But there is ground more than 100 feet from the lake, but it's within 12 inches of the surface, there's water. If we have an engineer that comes to us as part of the appellant, and they request a variance for that 12-inch height because of the shape of the terrain, the most ideal place to build a house and a septic combination on this limited size lot, it sounds to me like that's a reason for a variance, if they can prove that they can build a system on that that won't be harmful to the environment.
The way you just phrased it, the answer is yes. But the burden is on them to show that with the non-compliance with the water distance from the surface, the burden is on them to show that our standards are met. There's basically, as you just summarized, no adverse impact, right, on neighbors or on the environment. The burden is on them. But at the example you just gave, I think I could defend that in court.
Okay, so that kind of answered my second one, so I'm going to skip it. But I'm going to go back to the first question I wrote when you got started here. You talked about a variance and you talked about an appeal. Can that be one and the same, or do they have to specifically say, I'm looking for a variance or I'm looking to appeal?
Thank you. Excellent. Excellent question. There should be separate requests, okay? Remember what I said earlier about a person comes in with an appeal, and you just say, yeah, the appeal should be granted, but if you really gave us this evidence, you might qualify for a variance, but you've got to give us this evidence, and we'll adjourn while you get it. Okay, because remember, there's a public notice, because it's an open meeting. Do you follow me? And the public has a right to know what is being done at the hearing. So, if a person files an appeal, but it really should have been a request for an appeal and a variance, and or, it's got to say that in the application.
So it can say and or.
Yes, sir. Yes, sir. Yes, sir. And ideally, eventually, one of the other things that we're trying to do is, Dan has asked me, and this is probably my last work for the health department, working on a uniform application. Okay, so that I don't care what county you're a citizen of, you're going to be saying the same application, and that we help guide them to make sure the application is complete, because it's not fair to them to go out all the work and have it not complete, and we help guide them in what you just said, okay? Is it an appeal, or is it a variance, or should you ask for both, okay? Again, it's more evidence they've got to submit. The point is, I want to help guide the public, okay, by our applications and working on a uniform application to try and make it as efficient as possible, okay?
So can I expand just a little bit more on that, the terrain?
Okay.
And let's make the assumption that the applicant is coming with proof from an engineer that he can do what I'm going to ask. So we know that that's a requirement of the code. And on these same lots or similar lots, there is a place with elevated terrain that probably would be better suited for the septic. And the area of high groundwater isn't really a wetland, so in theory they could fill it if their house with wetland is, if they could get a variance to put the system closer to the lake. So they're going to come to us as an appeal board and say, hey, I have a really good place for a septic system, but it's 20 feet too close to the lake. But it's a much better piece of land, and I'd like to put my house behind that in the piece of land that won't qualify for my septic.
Okay. Then the key, my friend, to answer your question is, in their application, are they requesting an appeal of the denial by the health department, or are they asking for a variance? Okay, and again, I would hope that people would communicate with our sanitarians, and sanitarians tell them that the burden is on you, but really this should be a variance request.
But
And if they-
that is a feasible way to go about it.
Yes, yes, yes. They should be told, because obviously at the time of your hearing, you want to make sure they've got the evidence, right, to present to you to show the standards are met, or it's a waste of time. Okay? But they can, remember, you made a good point, they can request both at the same time. For some people, that may be the most efficient way to do it. Questions in the back, sir?
So if I could go back to the first question that you asked earlier about involving the engineer to, you correct me if I'm wrong, getting the engineer to design the system to go on that better terrain. I'm not denying that an engineer can do that. Engineers can do that all day, every day. You had mentioned, Jim, that then that would be supported and you would be able to argue that in court. But just because you can design a system for location does not mean that that system is necessarily going to function the way it should with respect to the treatment. If you're taking it closer to the lake, if you're taking it closer to groundwater, shouldn't that burden also be part of it? I mean, I can, not I, but an engineer can design a septic system to go on an asphalt parking lot and argue that it would work, but there would have to be an additional burden of proof to that.
Burden of proof is on them. Remember, one of the standards, granting the variance will constitute an improvement to existing conditions and will provide a greater level of protection to the health, safety, and welfare of the public, and will not be materially injurious to other properties in the area in which it is located. That burden, the way you described it, I would say the burden is on them. They've got to deal with that. Okay. Otherwise, if they just, that's one thing you just can't assume. Okay. The burden is on them.
So there's more than just the burden of designing the system. It's the functionality of the system as well.
Well said.
Okay.
It's a functionality. Yes.
I'm aware you're taking this too far, so feel free to say this is a later question. Is there, in the sanitary code and through the Board of Appeals, a process to discuss cumulative impact? For instance, if you have a number of homes that are all doing a variation on their septic system, but the home can be in the place that they want, in the septic system, all of them have been granted a variance, right? Is there any process by which you say, we may have provided a variance to your neighbor, but unfortunately, because of the cumulative impact of having 15 of these variances, you are no longer allowed, right? Is that in the consideration under the variance procedure?
And the answer is no, but perhaps it should be. Okay? I have never seen a sanitary code that's dealt with that issue, and that's a legitimate issue. Don't get me wrong. But on one hand, think about it for a second. You're balancing ultimately protecting the environment because there can be cumulative problems, right? 1 or 2 variances don't make a problem, depending on the size of the lake, right? I mean, the lakes around here are small enough that you get too many variances, it's inevitable there's going to be an adverse impact on the lake. Versus what we call equal treatment under the law. So people with similar circumstances are treated equally. Now, I'm satisfied under the law that if proper research were done, okay, to show that the maximum number of variances have been granted and that now you've reached the tipping point, do you follow me? That there could be a justification for denying a variance. I have never seen that. I've never seen it in a code. Perhaps there should be. All I'm telling you is it's a very legitimate question, okay? It's just a superlative question. I mean, I'd love to see it, okay, before I totally hang up my, my work. It's very challenging, but it's a good question. But the answer is I've yet to see any code that dealt with what you're calling the cumulative impact, but it is a legitimate concern. But it's not in our code right now. Maybe it should be. Maybe it should be something that you look nationwide. Have other people done that? How can we do it and adapt it here? Oh, one other thing. Please, my friends, if in an appeal you see something that you don't like in the code, okay, don't use your personal preferences and grant or deny something. When there should be changes to the code, mark them down, okay? Make sure they're part of the record and that it gets back okay? Proper higher up to the food chain, to our primary sanitarian or to the health officer, saying these are changes to the public health code that I want. I don't like this section. It's too loose, too restrictive, or we should look at cumulative impact, okay? In preparing for this, I've seen some sections that I'm going to be recommending that you look at, because amending a public health code is a complex process, okay? And one of the good things I've seen from boards of appeals, I've seen this in zoning, and I haven't seen it with our health department yet, but it could happen. You start recommending changes, okay, that we keep track of, and we make a list so that when we do a change to the code, because it's got to be a public hearing by the Board of Health, it's got to go to 4 counties, right? It's a complex process. So that we start making a list. So please, if there are sections and you're prepping for a hearing you don't like, you think are unfair, to whatever perspective you want, make note of it, make it part of the record, still apply the law, but make sure it goes up the food chain so that ultimately the health officer and our sanitarians are aware of changes that you don't like, so they can be considered when the time comes to amend the code. Got it? Okay? Because I've seen this, and I promise you, it's the most efficient way to do it.
Jim,
Sir?
forgive me if I'm getting ahead of what you may be speaking about, but the scenario of one property needing a variance and then the next property requesting a variance similar to that. Can you touch on precedent setting and whether or not decisions by these boards have precedent and are bound to similar decisions because precedent has been set?
I mean, under the U.S. Constitution, right? Equal treatment under the law. If the facts are reasonably similar, and there can be minor changes, but if factually they're essentially similar, the result should be the same, because you want people treated equally under the law. It's as straightforward as that, okay? That's why the law requires that there be standards for your decision, not just that in Antrim County you think, man, this makes sense to me, right? But in Emmett, saying, I don't like that. You don't do that. You apply standards that are the same, right, in every county.
And we had a conversation a day or so ago about this topic. That I asked you the question, does the decision made in one county potentially have precedent-setting implications on another county within the district?
And the answer, it could. I mean, if I were a plaintiff's attorney, and you granted an appeal or a variance, I represent a neighbor that thinks their well is going to be contaminated, or I represent an environmental group that thinks you're polluting river, and assuming I have standing to sue. What am I going to do? I'm going to look for other similar decisions anywhere in the district, okay? And I'm going to look for inconsistencies. So the answer is yes, it has an impact, okay? And I expect, I promise, well, I'm sure of you, from folks that have been involved with county, township, or city zoning, that when there's a tax on a ZBA decisions, they're going to look for inconsistencies in decisions, and it'll be used against you. Yes?
Jim, on a similar note to this, with the equal protection of representation under the law, and the statement was accurate, that the sanitary code has gotten more lenient. And the appellant shows up to you and says, house A over here and house C over here got an house system built out 20 years ago in conditions that likely were just like this lot, now you're telling me no today. And I hate to say it because these guys are doing a job, but aren't they making a mistake? And if we deny, are we making a mistake because we allowed those other two on the opposite sides of this lot to do that?
Great question. Everybody here, I want to thank you. The questions have all been not just good, but great. It's a question you have to apply the law at the time that the application is made. And the fact that prior ordinances either allowed or didn't allow something, to a certain extent, are not relevant because law changes over time. For example, the alternative treatment systems, ATS. I mean, years ago, when I started representing the health department, those weren't options, okay? So, my friend, you're applying the code as it exists at the time that the application is made, okay? And the fact that other people under prior versions of the code were allowed or not allowed something isn't the type of thing that's going to create a bad precedent, because the wording has changed. The law may have changed, okay?
But the law has become more lenient, and to turn somebody down today on a lot where it was stricter before they got it.
Depends on the facts, my friend. For me to answer your question accurately, I've got to have specific facts, okay? But on a theoretical basis, if it's more lenient, the question is, are those provisions, not talking generally more lenient, but are the specific provisions more lenient? Do you follow me? Overall, I think the code is more lenient, okay? The variance things we've talked about, that wasn't in there before, okay? All right, we got questions. Sir?
It's not so much a question as, I don't believe that the law is more lenient. It's just that the technology is allowing them to do more stuff.
That's a very good point. That is a very, very, very good point.
The better term is more options rather than lenient. With like,
Okay.
Yeah, I like that. There are more options now, okay? As technology improves, right? There are more options. Question to the back, sir.
Where does the health department stand? Where does, do you know of any action at the state level that is trying to get a state health septic ordinance or thing in process?
That's a very good point. I am not aware of any. Anybody in the health department?
Yes,
Mike?
there's been interest and action over the last 20 years, probably, maybe more than that, to get a statewide sanitary code. Many bills presented that have not passed. I think that part of that is that Michigan has, I forget how many districts, health districts, but 50, 60 health districts, each with their own sanitary code, varying requirements for site suitability, and for the state to come up with one set of standards that are scientifically sound would wipe out many areas of the state as far as being able to be developed. I believe, and I think it's from my authority to believe that has been the main reason why we haven't gotten to the statewide sanitary. I would welcome a minimum standard, but what is that minimum? Because a minimum standard would not really, I don't think, affect us. I think our code is progressive enough, and that the minimum standard would affect us. There would be other districts that do other things than we do, and some people on our staff have worked for these other departments. They may be able to tell you what they used to improve, but that has been, there is a driving force for it. There has not been a suitable proposal made that is appealing to enough of the people that make those decisions to pass on.
It comes up every 2 or 3 years, and somebody brings it up at a conference or something, and then there's some interest, and then it kind of fades out.
They've been trying to pass, there's a document that the state has, it's called the subsurface criteria for the state of Michigan. These are all for commercial uses and multifamily uses. Guidelines, they're not guidelines, they used to be guidelines, now they're criteria. They came out in the early 90s, and they've been trying to modify that document in reference to commercial wastewater systems and multifamily systems, and they've been working on that for 15 years now, and they haven't been able to get a document that can get past Congress and the state legislature on just that one document, let alone the statewide sanitary. Draft form. In fact, some of the stuff on that technical guidance document, groundwater monitoring came from that draft document that we just use their ideas of what they're thinking is appropriate monitoring criteria. That criteria is in that district health department, our district health department, technical guidance memo on groundwater. But it's not an official document. They've been trying to do that a long time. Just can't come up with something that everybody agrees on.
All right.
Just to clarify, our previous sanitarian director indicated he was not in favor of any current legislation that's been proposed. Again, talking about minimum standards, you would have a minimum state standard. That doesn't mean that that's the best practice for your area. And then probably the bigger concern is that we have a vulnerable environmental issue here where we have so many lakes and so many properties and uses of those lakes that what would work for us won't work for necessarily downstate, which is more of a suburban or city environment. And so, again, if it's a minimum, we'd still have, by all rights, we would probably still have a sanitary code in place that would be more restrictive than what the minimum standards would be.
Right, having a statewide sanitary code in the laws that are in the state of Michigan anyway, does not preclude the health district from having a more restrictive code. Right.
Okay. All right.
Restrict, depending on what you want to call it.
Casey, last question.
Yeah, I'm still trying to wrap my head around some questions that might be all together. Between this gentleman said, Dan said, and Karen said. So I don't know if there's a marker on that whiteboard and I can just sketch something out real quick. Is there?
Go ahead. While you do that, again, I want to thank all of you for coming. Obviously, I mean, I was the first attorney to actually, on a regular basis, help the health department on public health issues and intergovernmental issues. I care about this health department. I've monitored the chaos, and that's my word. It's occurred because of COVID and masking issues. Okay, some of you may have seen my presentation I gave in December a year ago to the Board of Health. I respect what you're doing now. I want to see things go well. I respect Scott and Scott's leadership. I respect the Board of Health and what they're trying to do, and I want to see things go smoothly. And obviously, to the extent that all of you have contributed working with me so that we help apply the code properly, we're taking a good positive step. So I personally, from an emotional perspective, thank you, because I care about this health department. Yes?
Okay. So what this gentleman in the tan shirt said. So it's not uncommon around some lake-like states to have like this hill. So you have surface water, a slope, and then it dives back down and gets back here. Right?
All right.
So if I'm following what your question said is, on the slope, like this could be nice and high and dry and compliance, but we're not 100 feet from surface water.
Correct.
Is that correct?
Yep.
So if it's a vacant site, it sounds like they can apply for a variance to put a septic here where it meets conditions. So if they grant a variance, like at what point can they? It's vacant. And then at what point, like how close can they get? Are there any requirements of that variance? Like,
First of all, the variance section has 4 criteria, all,
Yeah.
just the extraordinary and exceptional circumstances. So all 4 items would have to be met.
so strict compliance can't be achieved in exceptional and extraordinary use of force? Okay.
So you could, they'd have to make an argument for a fact, the applicant,
Right.
demonstrate that all 4 of those would be the case for the board to issue the variance, if I understand correctly, Jim.
Right. And thank you, Casey, for this example, because as we look at that 4th criteria, will constitute an improvement to existing conditions, I would take the position, if I were representing you folks and providing advice, that section applies to existing conditions only, not something brand new, okay? And that under this example, the focus is that the proper interpretation a court should provide us, okay, is that it's not going to be materially injurious to other properties in the area in which it's located. Now, who is that burden on? The applicant. What type of testing is required to show that? I mean, that's your area. But the point is there should be facts related to that. Okay? All right. Thank you. Wrap this up, please. All right. There's an engineer, a doctor, and a lawyer. It's Friday evening. They're done working. They're out having drinks. And they've known each other a long time. And there's always a friendly discussion, argument if you want to call it that. Which profession is the most important? And after a couple drinks, they're continuing to discuss this. And finally, they agree, there's got to be a standard by which we evaluate our respective professions. So they think about it, and they say, well, which is the oldest profession? Let's decide then that will be the best, the oldest profession. We all know what the world's oldest profession is. That doesn't apply here. So they're thinking.
You said there's water involved.
Yeah, exactly. That's why I have to limit myself. So it's only one of those three professions. So the engineer said, first the doctor interrupts the engineer who's going to speak and says, since we're saying the oldest profession, I'm going to say this. If God created Eve from Adam's rib, that's really a surgical procedure, right? You guys can't go beyond that. The engineer thinks and said, I kind of like your example there, but I'm going to take it a step further. If using a biblical reference, you then say, well, but God created Earth, the universe, laws of physics, all the things that apply. Think about it, out of chaos. That's really the job of a systems engineer. Doctor's eyes got real big, nodded. They both turned and smiled to the lawyer. Can't beat that. Lawyer points. Who do you think created the chaos? Thank you, folks.